Good evening. My name is Erwin Chemerinsky, and I have the great pleasure of being the Dean of the Law School. The McBaine competition is an enormously important part of the law school each year. And the McBaine Finals is always very special for us. It's usually held in the Booth Auditorium, usually with several hundred people present. It is, of course, the culmination of a long competition. And what we're hearing tonight is the finalists who have made it through preliminary rounds, quarterfinals, and semifinals to get here. We have three terrific judges, nationally respected jurists. I was so looking forward to our all being together in Berkeley, but since that's not possible, I am so grateful to each of them for taking time from their busy schedules to do this by Zoom. And I want to take a moment to introduce each of these judges, but I cannot thank them enough. And of course, some of them are on different time zones and it's late for them. And it's just so great of them to still do this for Berkeley Law, even though we can't be together. Our Chief Justice this evening is Stephen Higginson, a judge on the United States Court of Appeals for the Fifth Circuit. He's a graduate of Harvard College, degree from Cambridge University, attended Yale Law School. He clerked for Patricia Wald on the DC Circuit and Byron White on the United States Supreme Court, served for many years as an assistant United States attorney, and then was a professor of law at Loyola New Orleans Law School. He joined the Fifth Circuit in 2011. Our second justice is Allison Jones Rushing. She received her undergraduate degree from Wake Forest, and she received her law degree from Duke Law School. And I have to pause for a moment of special pride. Judge Rushing was my student at Duke Law School in my federal courts class, and I was so excited to get to invite a former student who's now a federal court of appeals judge to be one of the judges in the McBaine Finals. After graduating from Duke Law School, she clerked for Judge Neil Gorsuch on the United States Court of Appeals for the 10th Circuit, for Judge David Sentel on the United States Court of Appeals for the District of Columbia Circuit, and for Justice Clarence Thomas on the Supreme Court. She was a partner at Williams Connolly in Washington, D.C., and she became a judge on the United States Court of Appeals for the Fourth Circuit just last year in 2019. And our third justice tonight, is Justice John Streeter from the California Court of Appeal. He received his undergraduate degree from Stanford University, his law degree from the University of California, Berkeley School of Law. So it was wonderful to have one of our graduates on the panel here. He clerked for Judge Harry Edwards on the United States Court of Appeals for the District of Columbia Circuit. He worked at Orrick and Harrington and was a partner at Kecker and Van Ness. He became a justice on the California Court of Appeal in 2014. So the participants, those who are viewing can see we have truly eminent jurists to judge the moot court finals. This is being recorded and it will be made available to our community to watch, to hear the outstanding advocacy of the lawyers and the terrific questions from the justices. And with that, I'll turn it over to begin the proceedings.
Counsel, we'll call Ansel.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We'll call the first case for the day, which is number 19-247, City of Boise versus Robert Martin et al. Counsel, would you please approach the bench?
Thank you, Your Honor. Should I proceed?
Yes, you may.
All right. Thank you, Honorable Chief Justice, and may it please this court. My name is Marissa Medansky, representing the petitioner in this action, the City of Boise. And at this time, I would like to request 5 minutes of rebuttal.
Proceed.
Boise has two ordinances that criminalize public sleeping and camping. And the question before this court is not whether these laws are moral or whether they make for particularly good public policy, although the city, of course, asserts that they are both. Rather, this court has been presented with a question of constitutional interpretation, whether the Eighth Amendment, and more specifically, its prohibition on cruel and unusual punishments, renders these laws unconstitutional. The answer is that it does not, which is why the Ninth Circuit's ruling must be overturned. The Ninth Circuit's opinion and respondents' argumentation rest on a view of the Eighth Amendment.
Are you bringing just to be clear here, a facial challenge or an as-applied challenge?
So, Your Honor, we are appealing the Ninth Circuit's ruling. The original plaintiffs in the case were the individuals who are homeless.
Right.
And while they brought an as-applied challenge, I believe, to the ordinances, it has become a case about the facial applicability of the ordinances because the Ninth Circuit held that the City of Boise could not enforce its ordinances on a blanket level so long as there were not enough beds in the jurisdiction for all of the homeless individuals to reside there. So while it is true that there may be something in the Eighth Amendment that attaches to an individual after an individual has been charged with a violation of the ordinance, indeed that was what it was a dispute in Powell, whether Powell, the individual in that case.
Now, Ms. Medansky, I'm just going to ask for a little roadmap for your argument. Your threshold position is that the federal courts couldn't get involved at all, but are you choosing to go to the constitutional argument first?
So we discussed in our brief the constitutional argument first, so that can be discussed first. We could also discuss Heck first, and we believe that the Heck bar bars the claims for prospective relief in this case, but because the questions presented the Eighth Amendment issue before the question regarding Heck,
well, that's
the
fine.
issue they were.
Okay, on the Eighth Amendment, we do have Robinson and we have Powell out there as looming large cases of ours, precedents. I was looking back at the oral argument in Powell, and Texas was very emphatic that public drunkenness describes sort of a delinquent or deviant state. Would you agree that being homeless doesn't involve deviance or delinquency?
So certainly we would not support, and we would not come up here and say that homeless people are delinquent, that they are, deplorable. That's not what we're trying to argue at all. What we would say is that the behavior of sleeping in public is something that, just as the act of being intoxicated can be something that a city has an interest in preventing, so too can that act of sleeping in public. And that can be from a variety of reasons.
But when you say the act, I mean, the reality of someone who's so poor that they're destitute and outside, their condition is being unsheltered. It isn't the same act as a drunk who decides to go out into the public. So it does seem to me that unlike alcoholism or addiction, being unsheltered, being that destitute is purely a lamentable condition rather than a criminal act.
So there are two responses to that, Your Honor. The first is that Boise does not merely just criminalize public sleeping and camping as a rule. Rather, it enforces its ordinances contingent to something, the special order, which is described in the record at 140. And it's important to note that the special order has been codified into the Boise City Code. And under the Idaho State Constitution, the Boise City Code has the constitutional authority of the state of Idaho. So this is state law, the authority of the state in Idaho, not merely kind of the whims of the city's enforcement, as respondent characterizes it in their brief.
But you're only defending its constitutionality as to it being enforced when there isn't space, when there is space in the shelters, correct?
We would say that the fact that the special order is only enforced when there are available beds is a stronger constitutional argument because it tracks so closely with the Ninth Circuit's ruling in the circuit opinion. And
well, what constitutional right can you describe to us that turns on the vicissitudes of public or private occupancies? It seems very strange for us to define a right around whether they're beds or not.
Well, and that's precisely the problem with the Ninth Circuit's ruling in this case, Your Honor. The Ninth Circuit said that Boise could only enforce these ordinances so long as the total number of beds in that jurisdiction exceeded the amount of homeless individuals. So the Ninth Circuit said
isn't the rule that you're proposing, the ordinance itself, even more particularized than that? It's not just the total number, it's whether there's available beds and you haven't stayed too long at a particular place so that you're allowed to stay there. You're the right gender to stay there. Perhaps you don't have a religious objection to staying there. That's a very articulated test that doesn't sound like a constitutional standard.
Well, we would say, Your Honor, that we think these ordinances against public sleeping and camping are always constitutional, that individuals are always able to assert defenses to, whether that's an impossibility, necessity, these common law defenses, to being convicted under the ordinances. And that's very similar to not only what the Powell majority says at 536, the idea that traditionally when we assess the accountability in criminal law, the levers we use are defenses rather than saying a law is blanket unconstitutional. But it's also consistent with what Justice White says in the concurrence, the idea of an Eighth Amendment defense, which is the language he uses in footnote 3. So even if there is something, again, in the Eighth Amendment that allows an individual to challenge their particular conviction under a generally applicable ordinance, such as these ordinances in Boise, that is very different from what the Ninth Circuit held, which said that the city cannot even enforce these laws with regards to any individual who falls under the category of homeless, setting aside the difficulty of assessing who is qualified as homeless, who is in that status, how do you count the number of beds in a jurisdiction? Does it refer to an individual like Robert Martin, for example, who is one of the petitioners, one of the respondents in this case, the original plaintiff? He no longer lives in Boise. He lives in an area of Idaho that is 7 hours away. So is he counted as an individual who is homeless in Boise, or is he counted as an individual who is not homeless in Boise? So there's a lot of—
But counsel, I'm losing a little bit. These sound like highly particularized facts. What your city is doing is giving a misdemeanor conviction, prosecuting and jailing people for sleeping in public, essentially a trespass or a disorderly conduct concept. Is that correct?
What Boise does is, again, it has this special order. The special order says the cities can only enforce the ordinances when there are available beds in the shelters. And that is also reflective of an individual, the length of stay requirements in the shelter. So if you've stayed those 17 days at River Life and you can't go back, the ordinance can't be enforced against you. And if, there are other kinds of constitutional issues at play. The question of whether there's a First Amendment challenge that can be brought against the fact that some of these shelters have religious components. And we would say that the special order can expand and contract, and maybe there are other revisions that need to be made to it. But
so if it turns out that Boy Scouts are being allowed to camp out, you might have an equal protection attack. Or if the word in the ordinance sojourn is deemed vague, there may be a vagueness attack. You're just saying there's no Eighth Amendment vulnerability. Is that that's your very narrow argument here?
Yes, Your Honor. This is for us a question of constitutional interpretation. And indeed,
okay, but you urge in your brief, when you're saying this is an issue of just the Eighth Amendment, you're urging an originalist, strict, narrow interpretation. But when I just think broadly about the framers, they were frontiersmen. It would never occur to them it would be a crime to sleep outdoors in the forest, would it?
I mean, I think that's a question of historical hypothesization, Your Honor. And
right, but your brief was very emphatic that your position interpreting the Eighth Amendment is an originalist one, that we need to try to divine what they might have meant when they wrote the Eighth Amendment. And my point to you is these are people that the framers of the Constitution, George Washington, they would have never conceived of the government criminalizing sleeping outdoors, would they have?
The point that's being made in the brief, Your Honor, I believe, is not that originalism is the sole justification for this view, but that whether you have an originalist view of the Eighth Amendment, and we think that it's true that the founders were frontiersmen, but they also wrote the 10th Amendment in addition to the 8th, and they had a very strong concern for the rights of communities and cities to govern themselves. So whether you're an originalist and you're very concerned about what was in the minds of the founders, or whether you're someone who wants to look at Powell in a more expansive way, regardless of that framework that you apply to the Eighth Amendment, you're not going to find any support in Eighth Amendment jurisprudence for respondents' argumentation.
Your brief does suggest that the Eighth Amendment should only apply to modes of punishment. If we were to rule on that ground, would we even need to reach this distinction between conduct and status?
Well, Your Honor, it's true. I think the point is not that, and I apologize if the brief was not clear, that to say that the Eighth Amendment only is what you say would not be a true reading, because we have Robinson that says that states cannot criminalize status. So we know that there's a substantive prong of the Eighth Amendment, but we also know that this court has said in Ingraham that that prong needs to be applied very sparingly. And indeed, while Robinson is this powerful statement about how status crimes are impermissible, this court, and frankly no other court of appeals, has really taken that and run with it to invalidate any other generally applicable ordinance of the criminal law, with kind of the exception of the Ninth Circuit in this case. And indeed, the cases that we have to consider are not just Powell. For example, we've talked about due process and vagueness. And in Challenge in Papa Christou, which is a case about vagrancy, in City of Morales v. Chicago, which was a case about loitering. So the individuals were challenging those two ordinances, generally applicable municipal ordinances. They brought forward these 14th Amendment claims, but they also brought Eighth Amendment claims very similar to the claims that respondents are bringing forward, arguing that because these individuals were low income, they really, they sometimes didn't have secure housing, they had no place to be but, vagrants on the street or loitering on the street. But the court
is the only court of appeals that, other than the Ninth, that's considered an anti-camping ordinance, is that the, is there only one other? And I'm trying to think, Joel, the 11th Circuit?
There's Joel, and I believe the Fifth Circuit in the Dallas case. It might have gotten to the appeals level, but I'm not sure on the specific stat of that. But it's also true that the California State Supreme Court considered a similar ordinance, obviously not binding to this court. But
in that case, in the California Supreme Court decision, there was no discussion that I saw about the Eighth Amendment, was there? It was mostly an equal protection and travel attack.
I do think the Eighth Amendment was broached in that case, but I would have to go back and check. And indeed, we think that the court's own precedent is really sufficient to judge this issue.
And in Joel, wasn't it possible in that case to say more categorically than it is in this, that the ordinance there could be applied with categorically without the kinds of exceptions we see here, where there's contingencies based on the number of nights stayed. There's religious observance contingencies. This case seems like it requires a much more fact-specific line to be drawn than Joel did.
In Joel, I believe, Your Honor, there was one shelter in the city, and that shelter had ample space, and the shelter also did not have a religious component. So indeed, and the shelter had a lot of beds, way more than the city's homeless population. So there was, if the court was considering, the choice of an individual to sleep outside rather than seek shelter space, which is ultimately what these laws are targeting, not being homeless, the condition of homelessness, but choosing not to access an available shelter space. That was more clear. But
Ms.
here,
Medansky,
the special order
goes, all right, we may have a little bit of a time lag, but I'm keeping an eye on your clock. Just to be clear, before we ask you to move to the Hecht issue, are you asking us to overturn Robinson or not? What's the government's primary argument? Are you accepting that Powell embraced Robinson and you're therefore turning on the Powell revision of Robinson, or are you saying we should overturn Robinson?
Robinson, in Ingraham, we learned that Robinson's substantive check on the criminal law ought be applied sparingly is the language that the court uses. We believe that Robinson establishes a clear status act distinction, and this status act distinction is affirmed in Powell. We don't say overturn Robinson, but we say recognize that Robinson is a principle, but it's not a precedent. And we need to respect states' rights to criminalize behavior that states deem in their judgment should be criminal for anyone who engages in them because of the harms to the community.
Now, but attendant to your telling us that states should have the freedom to criminalize this entire quality of life world, you're also saying federal courts can't even make this judgment in this case, correct? Whether there was a constitutional violation or not, there's no federal court relief. Isn't that your position?
Yes, correct. We believe that the favorable termination requirement established by this court in Heck v. Humphrey is a bar to respondents' 1983 claims, because an injunction that affirms respondents' request for relief, it would necessarily imply the invalidity of their underlying convictions. And that triggers the favorable termination requirement that was established by this court in Heck. Now, it's true that there's kind of been this discussion about habeas ineligible individuals, but that's a red herring in this case. And the real issue in this case is not that respondents did not seek habeas, but rather that they did not achieve favorable termination, which is defined broadly, not merely—
Well, wait, I'm a little lost by your— Go ahead, Judge Rushing.
Oh, no, I was just going to say, I would like to ask you about that, because you pointed out in your brief that there are other avenues for obtaining a favorable termination, an appeal or a state process, but every process that you pointed to aside from federal habeas is in the state courts. And I think you also rightly pointed out that 1983 sprung up from a concern, it's the Ku Klux Klan Act, right? Sprung up from a concern that states weren't protecting federal rights. So how do you reconcile those two strands about the purpose of 1983, but then your argument that, well, somehow you could get a favorable termination in a state court, therefore the fact that habeas is unavailable is not something that should concern us?
Well, first, Your Honor, I think that question and some of the discussion rest on a false assumption that everyone can and should achieve favorable termination. Rather, there are situations in which favorable termination simply may not be accessible to an individual. And that's not a bug of the system, but rather by design, because the reason for the favorable termination requirements is not, as is kind of suggested in respondents' brief, this concern about habeas versus 1983, but rather a more primal concern about common law having two cases that have conflicting results, but they're both valid, finality, consistency, and also kind of the tort roots of 1983.
Right, but the whole problem though, that it isn't just a red herring. I mean, the circuits are quite split on this, and opposing counsel cites the Harvard Law Review note that points out we haven't yet seen a case where the defendant in the criminal matter is no longer habeas eligible. So that creates a gap. And Hecht, I thought, was designed to channel you either into habeas or you have 1983 available. But you're saying Hecht is now to be used to foreclose relief when you have neither option.
What we would say is that Hecht's concern is broader than habeas alone. It's concerned about the potential for using 1983 as a collateral attack on a still valid underlying state law conviction. And the hypothetical you suggested is actually addressed by Justice Scalia in footnote 6 of the Heck opinion. He talks about an individual who is convicted and charged with resisting lawful arrest. And then they're released. And now they want to assert a Fourth Amendment challenge against kind of the seizure that led to that arrest. Justice Scalia says in that footnote that that individual's claim is barred because of the favorable termination requirement, that individual would have no avenue for relief under the rule established in Heck. And
but we've never said words like taint or impugn. In other words, this defendant is not going to be able to overturn the misdemeanor conviction. That's on the books. They're looking for prospective relief only. So you have to rely on this, the necessary implication that it's tainted somehow. But those words aren't words we've ever used, are they?
Well, I think that to that you would have to look at the language in Heck itself. And although it's 487 where we get necessarily imply, and to necessarily imply the invalidity of something is different rhetorically and in its meaning from simply invalidating something. And it's sufficient that there would be this cloud, this stain over respondents' underlying state law convictions, because if this law were unconstitutional, it would necessarily imply that their conviction under that law was improper. So
there's a cloud. What's the problem with that? Why haven't we already decided this issue in Spencer? When you count up the votes, if you count Stevens's dissent, we've already said if you're no longer even eligible for habeas, you've got to be able to make your prospective attack. These homeless people don't want to get arrested again.
Because even I think if you look at the opinion in Spencer, and what we get out of a lot of these Heck cases is they come from when an individual is incarcerated, reflecting what Scalia observes in Heck, that 1983 is a very fertile source of prisoner litigation. So the majority of Heck cases are about individuals who are incarcerated and about this concern of where do we funnel to their claims? Do we funnel them into 1983 or do we funnel them into habeas? But the ultimate language that Souter uses at the end of Spencer is about people who are unable to achieve favorable termination as a matter of law. And again, favorable termination is not merely a successful habeas writ. It includes direct appeal. It includes expungement and invalidation. So when presented with the type of case that you mentioned that we talked about in footnote 6, circuits have ruled that the Ninth Circuit in Lyle, which respondents actually cites in their brief somewhat sneakily, the Ninth Circuit barred the request of an individual asserting a Fourth Amendment challenge to an underlying conviction using Heck, not because the individual in that case had not sought habeas. They said it was clear that that individual had no opportunity to seek habeas. The issue was that that individual did not challenge that conviction, you challenge
right, but
Fourth
here,
Amendment on appeal.
We're not trying to punish. What's the consequence of Martin's choosing to plead guilty? He loses his opportunity to make the 1983 claim? But so is there a foreclosure aspect to this? And I guess the related question would be, the record doesn't tell us whether his counsel told him, when you plead guilty, by the way, you won't be able to prevent your rearrest. You will not be able to challenge the constitutionality of this ordinance. So what's the significance in your argument of Martin's decision to plead guilty?
Yes, Your Honor. So there are several camps of how the circuits have addressed the favorable termination split. And some circuits say you're always barred if you haven't achieved favorable termination. And some say you're barred, but if you've made a good faith effort to achieve favorable termination, you can still get in the door under 1983. So those circuits, too, would not say that Martin has a valid claim under 1983 because they have willingly relinquished the opportunity to plea in their case.
But wouldn't we have to know whether he was advised that at a rearrangement? Was he advised that he's foreclosing 1983 relief? So my question to you is, if counsel didn't advise him of that, would that counsel be ineffective? Just as a lawyer is ineffective if they don't tell a client, oh, by the way, this guilty plea means you will be deportable.
You know, I think that would be certainly potentially the case, Your Honor, but it's not clear whether that would be the case because, as we've discussed, this court has been unclear about whether the favorable termination requirement applies to these individuals, which is why this court must emphatically say that the favorable termination requirement bars these 1983 claims so that counsels can be clear to their clients that they need to engage in these types of legal challenges if they want to have effective claims.
Ms. Medansky, let me take you back to something we started with. You know, accepting that the challenge that's been mounted here will turn on a very fact-specific set of circumstances. I guess I have a hard time seeing with the prospective relief that's being requested, what is necessarily implied, what kind of invalidity of past convictions is necessarily implied in a prospective determination? Wouldn't we have to know something about the specific facts of the past convictions to make the leap that there's going to be a necessary implication of invalidity?
I see that I'm out of time, so may I briefly respond to your question?
Yes, go ahead.
So there are two things that could happen. Either this court could say that these ordinances are always unconstitutional, which would necessarily imply the invalidity of convictions under those ordinances, because it would always be unconstitutional to enforce those laws. Or the court could affirm the Ninth Circuit, which has this bed-based numbers approach. And we know from the record that there has never been more beds in Boise than there has been homeless individuals. So we can retroactively apply that framework to understand that that conviction too would have been unconstitutional in that respect. And for the foregoing reasons, we urge you to reverse the Ninth Circuit's holding. Thank you.
Thank you, counsel. You've reserved 5 minutes for rebuttal. And now we will hear from Ms. Walters.
Thank you. Honorable Chief Justice, and may it please the court. My name is Emma Walters, and I represent respondents. This case is about ensuring that the protections of the Eighth Amendment extend to all citizens, regardless of one's status of homelessness. The city cannot criminalize its homeless population for sleeping, and this court is the only means by which respondents Martin and Anderson may seek relief. As such, this court should affirm the ruling of the Ninth Circuit for two reasons. First, a no sleeping ordinance violates the Eighth Amendment rights of those who experience homelessness, because not only is the ordinance ineffective, but it also unconstitutionally criminalizes the status of homelessness.
Now, Ms. Walters, my hometown is New Orleans, and we have a huge street people problem during Mardi Gras. And so the police certainly don't allow people to sleep on the neutral ground during Mardi Gras. And then tragically right now in our pandemic, the city has just decided to move all homeless people mandatorily into hotels. Would either of those actions fall into a limiting principle? Would those be constitutional ordinances for us to have?
Your Honor, those may be constitutional ordinances because the holding today, the ruling of the Ninth Circuit, is a limited holding. The holding, if this court affirms the Ninth Circuit, is just that the city may not unconstitutionally criminalize the status of homelessness by preventing outside sleeping when there are no shelter beds that are truly accessible. So this is a limited principle, and the city is still well within its rights to enforce different criminal laws to maintain the public health and the public safety.
I guess part of the difficulty here is the author of Powell was Thurgood Marshall, who was a pretty good defender of the disadvantaged. And as I read his decision, he just really struggled with what's the limiting principle. And am I correct that you would allow Boise to arrest if they urinate, or you would allow Boise to arrest if they block traffic, but they just can't arrest them if they're sleeping? And if that's the rule, how is urinating different than sleeping?
Your Honor, the hypothetical about public urination is an extension of an hypothetical that is not applicable in this case. If we truly lived in a world where there were no public restrooms and there was nowhere else to use the restroom, then such an ordinance that criminalized public urination may be deemed unconstitutional. But that is not the world that we live in right now, and it is beyond the scope of this holding. The city is well within its means to regulate activities that to protect the public health and the public safety.
I don't want to harp on these hypotheticals, but I do think it's a good question about the limiting principle. Another basic human need is cleanliness and bathing. As far as I know, there are not publicly available showers like there are, a restroom maybe in a Starbucks. What do we do about an ordinance that says you can't strip down and bathe in a public park, in a pond, or in a public swimming pool? How do we distinguish that from you can't close your eyes and sleep in the park?
Your Honor, the difference in these two hypotheticals, the current situation at hand, which is sleeping outside, and your example of public bathing, is there's different public health issues at stake. In the record, we see there was never a public safety health issue by people just closing their eyes, sleeping outside. In fact, we see in the record multiple times where someone just laid down to try to get a few minutes of sleep. That is very different than imposing a public health hazard on the rest of the community. So those two situations are in fact different. And more generally, Robinson and Powell both draw a dividing line between status and acts over control. Because Robinson told us that the government cannot criminalize the status of their citizens, and it is cruel and unusual punishment under the 8th Amendment to criminalize such a status. This is different than an act because a status is outside of one's control. For example, this court—
But isn't the act here the identical act that Justice White found was the critical additive? In other words, going into public with the state. So there the state is alcoholism, but you go into public. Here the state is sort of destitute, you're poor, but then you choose to trespass on public land. You take an act.
Your Honor, being intoxicated in public and sleeping in public are two very different things. This court in Powell made it clear that in that case, the individual who was an alcoholic did have choice over whether to drink outside, where he could drink. In that case, he did have a house. And also, drinking is not a necessity of life. And he also took that choice to take a first drink. However, in this case, sleeping is a requirement of life, regardless of whether one is housed or not. And when a city criminalizes a necessary function of a status, they are criminalizing that status unconstitutionally.
Ms. Walters, the opinion that we're reviewing here takes a rather interesting approach to the Marx rule. I guess I'm interested in number one, whether you're going to stand behind that 100%. You know, taking 4 dissenting votes plus one point of view expressed in a concurrence as the rule announced in the case, and number two, is that the right interpretation of Marx?
Yes, Your Honor, this is the right interpretation of Marx. When you have justices on the Supreme Court who do not completely agree in the reasoning, it is important, and Marx has told us that we need to read the narrowest concurrence, the concurring opinion among all of the judges. This is an important guiding principle for the exact same elements of finality that the city contends.
Well, but it seems like, you know, the 4 votes added to the 1 are not concurring votes, they're dissenting votes.
Are you referring, Your Honor, to the Powell decision?
Yes, I'm referring to Powell and how you get to the idea that involuntary conduct that's somehow inseparable from conduct can come within the Robinson holding.
The justices in Powell agreed, all of them across the board, that the difference between this act and status is an element of control. Again, in Powell, the question was being intoxicated in public, which has an element of control. However, for homeless individuals, it is a chronic status. And we know this by multiple data points. The majority of people who are currently homeless have in fact been homeless before. And we also know that homelessness is caused by external factors outside of one's control, including poverty, mental illness, and lack of affordable housing. So, and we can see this specifically with these specific respondents. With respondent Anderson, on the record at page 117, we saw that he was temporarily able to gain shelter by living with his girlfriend. But once again, he fell prey to the chronic status of homelessness and ended up on the street where he was cited under the unconstitutional.
I follow the argument, but what I'm getting at is whether you want us to hold that now in the first instance, or whether it is your position that we ought to apply Marx as the Ninth Circuit did and say that this is already the law.
Your Honor, I would we're asking to affirm the Ninth Circuit and say that this is already the law. Robinson set the groundwork, Powell followed up on it, and Marks told us how to read that Powell determination, which is exactly what the Ninth Circuit did, and is exactly what respondents are asking today.
Are you saying that the city, I guess I'm wondering, what is cruel and unusual? Is it putting your client in jail for being homeless, or is it arresting them in the first place? In other words, could the city arrest them, but then take them to a hospital? In other words, are you telling us that the arrest itself is unconstitutional, or only the jailing?
The arrest itself is unconstitutional, Your Honor, because Robinson said that we cannot criminalize anyone's status. And in Ingraham, the court laid out 3 different principles of where the Eighth Amendment applies. And one of those is criminalizing something in the first instance. And
but am I right that the Powell court did not accept, at least it was the ACLU's argument, that criminal misdemeanor sanctions can't be used for rehabilitative purposes, really, to have someone just sleep off a drunkenness? So is your argument predicated on the fact that our court should intervene to disallow criminal misdemeanor laws to be used to combat social ills? And if that is your position, which I thought it was in your brief, I don't see that our court accepted that in Powell. I think our court has consistently said that cities can use criminal misdemeanor offenses to combat social ills.
Your Honor, that is absolutely correct. We can use criminal sanctions to combat social ills, but what a city or a state cannot do is use criminal sanctions to unconstitutionally criminalize a status in the process. So while a city could, for example, and has criminalized drug use, public drunkenness is allowed under Powell, that because those are social ills, one in the process cannot criminalize the status of a citizen.
Counsel, what about enforcing this ordinance against someone who doesn't have the status of homelessness? Say they have a home, but perhaps they enjoy the sort of wandering vagabond life and occasionally sleep outside, or as your friend on the other side suggests, they're involved in gang activity and are looking for cover by sleeping on the streets rather than being associated with their actual residence. Would it be constitutional to apply the ordinance to those people who don't have this status of homelessness?
Your Honor, I would argue that if someone is feeling like they need to sleep outside, in your example, because of gang-related activity, they are part of that status of homelessness. Homelessness doesn't mean that you are outside every single night of the year. It means that you are forced outside by forces outside of your control. And we know that homelessness is chronic and a cycle. And what I think you're getting at is a little bit of White's concurrence in Powell, which suggested that maybe we should do a case-by-case analysis. And I think it's important to recognize that there's sort of 3 arguments that fit why this ordinance can be criminalized, why this ordinance is unconstitutional sort of wholesale in this specific case. It's important to recognize that if we try to determine on a case-by-case basis if there was some volitional aspect of one's status of homelessness, it would waste huge amounts of judicial resources and really bog up the court.
Why could it be your friend on the other side says it could be part of a defense, and that doesn't seem like that would waste that many resources. If someone's going to have to come into court and plead one way or the other on this misdemeanor, and they could plead not guilty because they had no choice, right, but to sleep on the street because they were barred from all of the shelters. Why is that not a better approach than a sort of wholesale Eighth Amendment attack?
Robinson has told us that you cannot criminalize a status. So even the act of bringing that person in and arresting them under an ordinance would be unconstitutional under Robinson. And it's also, homelessness, no one chooses to be homeless. And that is exactly why homelessness is a status, regardless of whether it's caused by poverty or mental illness or violence.
Has any circuit court or state Supreme Court invalidated a substantive criminal law on Eighth Amendment grounds since Robinson?
Jones versus the City of Los Angeles recently struck down a very similar ordinance because exactly under the same grounds, under Eighth Amendment grounds, the ordinance in that case prohibited sleeping outside, and the Ninth Circuit in that case said that that was unconstitutional under the Eighth Amendment. And the city—
Were they just following the authority in the case that we have under review now, or did it precede this decision?
Your Honor, I don't have the exact date on that, but I'm pretty sure it preceded this decision.
Okay. I'm surprised this decision then didn't cite that one, but I guess what I'm asking you is, any court other than the Ninth Circuit, any highest state court or circuit ever invalidated an ordinance using the Eighth Amendment since Robinson? And if not, why? Why do you think not?
We know from Ingraham, Your Honor, that this power to invalidate the substantive law should be used sparingly, and we do not contest that. And the city argues that this is not a role of the courts, and it's not the role of the Eighth Amendment, that it really should be left to the legislature. But it is exactly the duty and the province of the court to step in to protect the constitutional rights of its citizens. The Eighth Amendment is part of the Bill of Rights, and like its origins in the Magna Carta and the English Bill of Rights, the American Bill of Rights was meant to protect subjects from state abuses of power. Robinson did this, Jones did this. And even if this power is used sparingly, it's important that this power is maintained to protect the constitutional rights of citizens. The criminal justice system is meant to serve either deterrent or rehabilitative functions, but the ordinance in this case does neither, and it violates constitutional rights and wastes resources in the process. Imposing jail time or criminal sanctions on an individual will not stop people from sleeping outside, exactly because homelessness is a status. The only true cure to homelessness is through substantive reform, and data shows this through affordable housing, mental health services, and the like. Criminalization through the ordinance does not get to the heart of the homelessness crisis.
Now, counsel, just, go ahead, Justice Streeter.
I just wanted to ask about your opponents. A major theme in your opposition's brief is that cities should have available as one of the tools, as they put it, an option in dealing with this intractable problem of homelessness, the ability to enforce laws like this. What's wrong with that perspective?
Your Honor, I'm sorry, you cut out for a second. Were you asking to
why shouldn't cities have this kind of the ability to enact this kind of law in their toolkits as one of the many options available to them in dealing with this difficult problem of homelessness?
Yes, Your Honor. The city is indeed encouraged and able, and this court encouraged cities in Powell to directly address the crisis of homelessness while also taking into account public health and public safety. What it may not do, however, is to criminalize the status of homelessness without providing substantive and accessible alternatives. So in fact, declaring this ordinance unconstitutional doesn't render the city powerless at all. And in fact, the city has a wealth of tools to combat the very, very real crisis of homelessness. We've discussed some of them. And for example, in Los Angeles, the city recently limited the property allocation that homeless individuals may have to protect the public health and safety.
You know, one effect or implication of the line of argument that you're suggesting is that so long as cities provide the available shelter for homeless people, it's possible for them to deal with this problem in other ways. Judge Smith's dissent, dissenting from rehearing in this case, goes into quite a bit of detail about how that will require municipalities to expend all sorts of money on this problem. So I go back to this idea that shouldn't cities have at the ready a number of different options, one of which is building more housing, and one of which is intensifying enforcement. Isn't the right answer a mix that's appropriately for elected representatives?
Your Honor, the city should address the national crisis of homelessness, but it cannot violate the constitutional rights of those in the process. And with regards to the special order or the revision on page 80 to 81 of the record, in fact, it does nothing to mitigate the unconstitutional effects of this ordinance for two main reasons. First, the shelters impose religious requirements, and this court has said that under the First Amendment, a city cannot force participation in religious programming using the threat of criminal sanctions. Furthermore, the shelters impose timing and demographic requirements. Putting all these things together, it means that the beds, while there may be empty beds, those beds are not truly accessible. And that is in contrast to the 11th Circuit holding in Joel versus the City of Orlando. In that case, the 11th Circuit upheld a similar ordinance, but in that case, the shelters never turned away anybody, and there were no requirements, meaning that the beds were truly accessible. And we also know, looking at the record, that even if the shelters didn't impose these requirements, there will always be, in the city of Boise, more people experiencing homelessness than there are.
Ms. Walters, it may be we have two issues in this case, and this one does sound pretty difficult and intractable. So the threshold issue for us is your client should have made these constitutional attacks at the right time, but didn't go on direct appeal and didn't go to state habeas, and therefore Congress has said you've exhausted your right to throw such a cloud over your client's convictions. You just don't get a second bite at the apple coming at it with 1983 and discovery and getting a jury. It's just not something Congress has allowed. How do you want to start answering that?
Yes, Your Honor. The respondents' claim requests for relief, for prospective relief, are not barred by the procedural heck doctrine, because to prevent against future enforcement of this unconstitutional ordinance, respondents need prospective relief, and it does not invalidate their underlying convictions. So it's not.
Well, but wait a minute. But you're not denying that they could have challenged their convictions, that making the same constitutional arguments you're making now, but they would have been circumscribed by the myriad restrictions that Congress has imposed through EDPA. So by waiting now conveniently, pleading guilty, and you didn't plead conditionally, you didn't preserve any right to attack your conviction, it sure seems like now the necessary implication of us saying these ordinances are facially violative of the Eighth Amendment would be that there is, the implication is that they shouldn't have been convicted. Those should be expunged.
The request for relief in this case, for prospective relief, does not necessarily invalidate the underlying convictions.
But you conveniently skipped our word implied. It doesn't necessarily invalidate, but it does necessarily imply that the convictions are invalid. No?
No, Your Honor. And we can look at a very similar case in this court held in Wilkinson, that the court upheld a 1983 challenge to the enforcement of future parole procedures because those claims in Wilkinson fell outside of the court of habeas.
Right, but I'm going to interrupt you just because those are procedural rights. So, but here you're asking us to invalidate the very substantive law. Isn't that the distinction we've been drawing in Edwards and Wilkinson? You can attack prospectively procedures, but you can't attack the law that you've been convicted under.
The distinction in Edwards and Wilkinson is not about procedural versus substantive. It's about whether the requested relief will necessarily imply the invalidity of the underlying conviction. In Wilkinson, when the city, given this court's order, when the city said that you need to use new procedures, it necessarily means that those old procedures are no good anymore. But the individuals were still allowed to proceed with their 1983 claims and not barred by heck. This is a very similar situation. Respondents in this case are not touching their underlying convictions. Their records aren't being expunged. They're not seeking back.
Well, when you say they aren't, they still could move to expunge them, couldn't they?
They could move to expunge them if they had not, well, they couldn't do it through habeas, first of all, because they are outside of the
Right,
court.
no, we know that.
Right. So, and secondly, the majority of people convicted under the ordinance plead out, thereby forfeiting their appellate rights.
But they could plead conditionally and reserve the right to challenge the conviction. But your client didn't do that.
We are dealing in, the individuals implicated under this ordinance are indigent clients for the most part and relying on public services. And that is, if there is, and we don't know from the record, there could be an ineffective assistance of counsel claim, but heck, and that is a separate issue, but heck was not meant to bar these sort of claims. Rather, heck was just meant to give states an opportunity to remedy their own errors before turning to federal solutions. In essence, it was meant to prevent against duplicative procedures that would challenge the finality of those underlying convictions. And here, the finality of those underlying convictions are kept in place. The respondents are not asking for backwards facing relief. They're not trying to get their records expunged. So those convictions are there. They are not going anywhere.
Well,
And
Ms. Walters, would assume with me for a moment that there had been an appeal of the convictions that followed the citations in this case. And that appeal had been litigated to the appellate courts in the state of Idaho. And there had been an Eighth Amendment argument raised in that appeal, which resulted in a reversal of the convictions. Assume that, okay, establishing the law of Idaho that in the factual circumstances of that case, the conviction there was invalid. Why would that be an inadequate remedy for your clients here?
it's an inadequate remedy because heck, looking back towards heck was not meant to be this procedural roadblock that requires that an individual definitely could have done that. But first of all, it wouldn't have gotten you into the federal court. It would have kept you in the state court. And heck was not meant to be this procedural roadblock that would require people to be in prison, continue a lengthy state process. That was not the intention of heck.
Well, isn't it the case that our colleagues in the state courts are subject to the supremacy clause, just like we are, and when asked to decide an Eighth Amendment issue, would do so, just like an Article III judge would?
Yes, Your Honor, everyone is bound by the supremacy clause, and that's why in this particular, the respondent or the city tries to make this expansive holding, but this is a very limited holding. It's saying in this case, respondents may seek 1983 relief without violating the procedural heck doctrine because it falls outside of that court of habeas and because they had no other opportunity to appeal their underlying conviction.
How heavily are you relying on Spencer? And if you are relying on Spencer, how do you get to 5 votes?
The majority of justices in Spencer said that when habeas is impossible, an individual can go straight to 1983. And we know this is the rule because once again, Marx comes up, and we know this by reading the narrowest concurrence. And we also know that circuits across the country have relied on this rule, including Lyall and Nanette in the 9th Circuit, Twang versus Johnson in the 2nd Circuit, and Carr versus O'Leary in the 7th Circuit. The city reads into what the court has not said, but the respondents in this case are merely relying on what the majority of justices have said to hold that when habeas relief is impossible, an individual can go straight to 1983 because heck was not meant to be a procedural roadblock that impedes individuals from validating their valid constitutional civil rights claims.
But in Spencer, we didn't actually invalidate the favorable requirement, did we? Favorable determination requirement?
No, Your Honor. It was a narrow holding that when habeas relief is impossible, you can go straight to 1983. And we know.
But isn't that impossible to harmonize with Heck's favorable determination requirement?
No, Your Honor. Heck refused. In fact, this court was asked in Heck to extend the favorable termination requirement to all 1983 cases, and this court refused to do so. And it implied in footnote 7 of Scalia's opinion that claims that didn't challenge the underlying convictions would not be barred by Heck. And so this court chose not to do so, and Spencer holds that when an individual cannot achieve relief through habeas, they could go straight to 1983. And under 1983, we know it does not require exhaustion. Going back to Marbury versus Madison, we know that there can be no right without a remedy. So in this court held in Wolf versus McDonald, that without the ability to seek redress in the courts for constitutional civil rights violations, the rights guaranteed in the Constitution would lose meaning. As such, in conclusion, the city should pursue measures to address the national crisis of homelessness. However, it cannot use the criminal law to violate the Eighth Amendment rights of its citizens in the process. The ordinance imposes cruel and unusual punishment, and prospective relief is necessary and available under the Heck Doctrine. As such, this court should affirm the judgment of the Ninth Circuit and enjoin the city from criminalizing its unhoused citizens.
Thank you, counsel. Ms. Medansky, you have 5 minutes for rebuttal.
Thank you, Your Honor. I want to start with 1983 and the favorable termination requirement, because respondent and petitioners have very different interpretations of Wilkinson, and we believe that Wilkinson very strongly illustrates why the favorable termination requirement ought apply in this instance, because in Wilkinson, the individuals in that case were seeking new parole hearings. And the court conceded, respondent has talked about, well, these respondents aren't seeking to invalidate their underlying convictions. But in Wilkinson, the court concedes that the reason an incarcerated individual challenges usually their parole hearing is because they want to challenge that underlying conviction or their confinement. They want to get out of jail sooner. The intent is not operative, nor is the nature of the relief, whether it is forward-looking or backward-looking. The sole relevant question is its necessary implication on the underlying relief. And here, we believe that it casts that necessary implication because unlike a parole hearing that could have come out in the favor of those individuals or might not have, an injunction that declares these ordinances unconstitutional would necessarily imply the invalidity of those underlying convictions.
Mr. Medansky, I guess I'm just not seeing what core concern of the habeas process is at stake here with no confinement.
Your Honor, it's not about, and the termination requirements is about more than just the concern of habeas. That is kind of how the opinion has been read because it comes after Prizer, which is concerned specifically about the interplay between 1983 and habeas. But Heck takes on a broader...
Isn't that the font of all of this entire line of authority, Prizer?
It's the font of the entire line of authority, but the question that we're addressing is different in this case because this is not a case about individuals who are challenging a condition of their confinement or a condition of their incarceration. And indeed, it's no accident that a majority of these cases are often about the conditions of prisons, parole hearings, good time credits. And in that instance, there would, the need for this kind of favorable termination requirement is different because an invalidation of your underlying conviction wouldn't get you your good time credits back. The relief that's being sought is different. So here, the true nature of the favorable termination requirement, which is about more than just habeas, it's about this common law root of malicious prosecution and the limited tort established in 1983 is more important than ever. And it underscores, because if it were just about habeas, there would not be 4 avenues of favorable termination. You would have to satisfy a habeas requirement and not a favorable termination requirement. But here, because this favorable termination requirement is about our need not to have these conflicting opinions, it applies. And application of this requirement would perpetuate no unfairness because respondents have the ability to challenge those convictions in the state court. But moreover,
Well, they had the ability, but they wouldn't be able to get discovery. They wouldn't be able to get to a jury. They're very, very hampered if they're doing it through state habeas. And as opposing counsel said, in that process, usually you don't even have counsel.
respondents could challenge on direct appeal. That would also have been a possibility. So just because the circumstances are not ideal for those individuals does not mean they have a legal right to surpass the favorable termination bar. But also, let's be clear on the Eighth Amendment question. These ordinances do not criminalize the status of homelessness. They criminalize sleeping on the streets for every individual in Boise. Whether you're a prince or a pauper, you cannot sleep on the streets.
Which seems, do you agree with me? There's a little bit of irony that these very individuals are being criminally prosecuted for sleeping on public ground, but all they're taken to is a public jail, and then they sleep in the public jail.
I think that's certainly an irony, and I think someone could cite to Robinson and Powell their discussion of the rehabilitative purpose of criminal law as well. And I think that would only strengthen our case that, you know, we see engagement with the criminal process is not necessarily just intended to serve a punitive purpose, but also a rehabilitative purpose. And when we see an individual engaging in a behavior that causes universal harm on society, you know, respondents aren't the people who should determine what behaviors Boise should criminalize, if that's public urination or any, you know, sleeping on the streets, nor is this court. The court should defer to the judgment of Boise, the people on the ground who are making these ordinances. And
aren't you underplaying a bit the effect of a criminal conviction on an individual's life? You know, there are various citations in your opponent's brief about the impediments to employment and impediments to all sorts of basic necessities of life, not just in the immediate aftermath of the conviction, but for many years to come. Isn't this applying a howitzer to a pretty small problem?
I see them out of time, so may I just address your point?
Yes, you may.
Sure.
The city of Boise takes no pleasure in citing homeless individuals under these ordinances. And that is why the city has a special order that carves out a variety of exceptions for homeless individuals. And indeed, when all of the beds in the shelters are full, if that circumstance were ever to occur, it would be permissible for those individuals to sleep in public. What the city is saying is that sleeping on the streets, just like a host of other behaviors, can and does cause societal harm. And the city has a right to regulate and enforce against that societal harm. And for those reasons, this court must overturn the Ninth Circuit's ruling and find in favor of petitioner.
Thank you, counsel. The case is submitted, and we will retire to have our conference discussion.
Now.
So we're back in there. You both are. That was spectacular under the most difficult circumstances. I really hope for both of you, and I think I can safely predict that for your careers, you won't have to face judges across the entire country on Zoom. But we were so impressed. It's no surprise you've gotten here as the finalists. Most moot courts, they're teams of two. So for you both to be able to handle both issues, very tricky issues, divide your time, show complete confidence with the case law, and confidence just in your poise and demeanor, I was truly impressed. We're each going to give you some compliments because you were both that good. And then at the end, it will be my obligation to score one of you a little higher than the other. So Justice Streeter, would you like to begin?
Yes, thank you. And let me just echo the comments from Justice Higginson. You were superb, both of you. This is the level of oral argument that all of us very much value and appreciate. And for you to be starting off your careers at that bar is truly an impressive thing. So fantastic job. Starting with Ms. Medansky, I just have a couple of brief comments about your presentation. I was very impressed with your ability to switch gears on your feet when you encountered something that was a little unexpected, including, which often will happen in oral argument, the very first question for me, I think, put you on your heels a bit, because it showed that you needed to frame the issues in a pretty basic way. And that kind of thing happens. You got to be ready for it, and you're going to come into an argument with a plan, and you've got to be able to recalibrate and then go back to your scheme of doing things, which you executed perfectly starting from the outset. I thought that your presentation on the substance in two very difficult, thorny areas of law was organized and focused. You were able to smoothly move from one issue to the next without prompting from us, and to continue the logical chain of your argument. You answered the questions from us directly. That's, you'll hear from all appellate judges. One of the things that irritates us the most is when we ask questions and we don't get a direct response. And you answered directly and with great candor, and also a fair amount of forcefulness. I thought your demeanor showed a great deal of confidence, and your rebuttal was strong. I frankly, thought that there was very little to criticize. I know that constructive criticism is a big part of this, but from this particular judge, I was very pleased on all quarters. I would say the same thing about you, Ms. Walters. Every single category, from the opening to the closing, was strong, well organized, crisp. There were occasions when we pitched things at you that I think that were a bit unexpected, and you paused and gathered yourself and went back to your major theme. And I thought that the thematic approach that you took, returning again and again to the same theme, the city just can't do this if it violates the 8th Amendment, was very effective. We heard that throughout, and you worked it in lots of different ways. You too showed great confidence. I particularly liked the pace at which you delivered your arguments. I mean, this is something that I think all of us had to learn as lawyers. We have so much information in our head when we go into a situation like this that it tends to come out in rapid fire fashion. But you have a nice, even pace to how you deliver verbally. And that is a great skill and is very important to effective advocacy. Great job.
Justice Rushing.
Sure. Well, I will say as well that you were both just excellent. The advocate, ideally, in an ideal world, the advocate is the master of the case, the person who knows the law and the facts better than anyone else and is really able to weave it all together. And you both were the complete masters of both of these very complicated and difficult questions that have divided judges around the country. So I was very impressed. And if we were actually having to decide this, I would have been very helped by the presentation that you gave, which is exactly what you want to do, is to help the judges by knowing everything you can about it. So kudos to you both. I'll start with Ms. Medansky for specific comments. I thought you were very well prepared. Nothing seemed to catch you off guard. If it did, you really masked that well. I was very impressed with your flexibility in responding to questions. So, whether we were taking you down a path about a line of cases that was not helpful for you, or that was a bit off topic, you were very flexible in being able to address what we wanted to talk about, and then make it a strong point for your own case, and then get back to what you wanted to focus on. And that's a real skill in dealing with oral arguments. So I thought you were very flexible with responding to questions. And you showed us that you understood the bigger picture of the case, both in your affirmative presentation and in the way that you answered our questions. You gave us a specific answer, but you also kind of backed out and showed us that how it fits into the bigger picture in deciding both of these complicated issues. So your preparation, I thought, really was evident. I agree that your demeanor was good. You're very confident, and the rebuttal especially, I thought, came across as a nice, compact answer to the things that seem to be troubling us the most. And again, I think your ability to return to the themes and the points that you wanted to get across was well done. So congratulations on such a job well done. Ms. Walters, you also, I liked from the very beginning, you gave us a very clear roadmap of where you were going, and there's no question throughout the argument of what your position was on these issues. You also, I think, showed us how well prepared you were, both legally and factually. I think you, by arguing the respondent side, you had the ability to kind of marshal some sympathetic policy arguments and facts, and I thought you did that really well. It didn't come across as though you were trying to skirt the law, but that you were raising important points that we should consider when looking at the whole picture and not just the legal analysis. So I thought you handled that well. That can be tricky sometimes. Again, I thought you were also very well prepared, and that really shined through. I'm probably reiterating what Justice Streeter was saying about returning to your themes. When we asked questions, or when it was time to pivot, you very clearly had the themes that you knew were important to get across. And as I said, there's no question about what your position was. And I also thought you projected loads of confidence. You, as has already been pointed out, you resisted the urge that's so natural to all of us to speed up and exclaim when we have a lot to say. And I liked that you didn't get rushed by all of that. So congratulations to you as well on a really outstanding performance. And I think the judges talked about privately, I hope you both get to send this recording to your parents or family or friends or other people who will be very impressed with your abilities. So well done.
I recently was at a sitting in Oxford, Mississippi, and we were speaking to students, and a student asked me the question, what vexes you most about your job? And used that verb, vexes me. And I thought about it, and I said, one of the things that really vexes me is that I can never compliment lawyers right after they do a great job. It's just not part of the choreography. You can't step down and say, you were terrific. But moot courts, I particularly enjoy them because we can do that. And you both really were, as I said before. That's not to say, even though you may be the best in your entire law school, and you clearly are superb, never think you can't learn. And your dean is the best one to learn from. So first thing I did when I saw there was an Eighth Amendment case is I went and looked on Oyas to see what arguments he'd done. And did you both know he argued an Eighth Amendment case in the Supreme Court? You did, yes. One thing you'll notice about his argument style, which is different at a younger age, is this is his second, third, fourth, and fifth answer. That's correct. I disagree. No, I have 2 points. So you'll learn often just this staccato, you give an immediate abrupt answer. And then if the court lets you, you elaborate. But I'm gonna give comments about both of you about what impressed me. But first, of course, I wanna thank your dean and the law school. They're making it seem like we've done you a favor, but trust me, appellate judges around the country are sort of yearning for the old rhythms. And this gave us a really immediate chance to have an oral argument. I haven't had one since the pandemic started. So I did prepare maybe over much for this, but you and the law school did a favor, and no other law school that I had moot courts did. So you also have to thank your colleagues on the moot court board. They picked a terrific problem. You know how hard it is with splits and 5-4s, difficult issues. The 3 points I want to make, because I don't want to keep you up too late. Normally, I can distinguish between lawyers in terms of who's more exact with their references, but you two were spectacular with the record, with specific justice opinions. You both knew the intricacies of circuit decisions like Joel. You were so well prepared. A judge on my court I admire, Carolyn King, told me when I joined the court, because she knew how nervous I was, she said, Steve, don't judge the cases, just lawyer them. Just know your facts in the law so the court trusts you. And at the end of both your arguments, I had complete trust in the accuracy of the statements you were making. So that is the biggest compliment I could give to you equally. In terms of one comment about each of you, Ms. Medansky, I thought you were really good at what top-notch lawyers can do, which is turning a weakness into your strength. So I'm remembering mostly what I was asking you. I did say to you, well, wait, isn't your constitutional one rule that turns on contingencies and vicissitudes? And you were able quickly to say, well, that's the problem with the Ninth Circuit rule. That was a nice little pivot. Then I asked you about frontiersmen, and it took you a minute to adjust, but you did adjust, and you said, well, they still liked government power. And then in the rebuttal argument, I said, isn't there an irony here? And without seeming dislodged, because that's really an unfair question, whether there's an irony here, you said yes. You didn't scare away from it. You said, yes, there's an irony, but then you immediately came back and stressed that rehabilitative purpose behind criminal law is legitimate. So you're very good at accepting a hard criticism and getting back to your strength. A variant on that, Ms. Walters, when I began oral arguments for the government, I always would remember this game that I played as a kid called Chutes and Ladders. I don't know if you know it, but if you get on a chute, you go all the way to the bottom. And I looked at oral argument that way. I just dreaded the question I thought would just kill me. It takes a lot of what I think of as both confidence and expectancy. And from the first minute, I sensed that you expected to win for your client. And that's an ineffable quality. It's an ineffable quality, but I detect it in lawyers. You wanted your client to win and you believed in that. You had sort of a trait that I think of as rehearsed spontaneity. When we ask you weird questions, it seemed as if you just spontaneously had prepared it. My guess is it's come up before, but the 2 times I threw questions at you that you had really good recoveries for. One, I said, well, is your position that you can never use the criminal law to address social ills? And without missing a beat, you said, oh, absolutely cities and states can do that, just not when it's criminalizing status. So that really cabined my question beautifully. Then you did it again when I said, well, your client didn't have a conditional plea, which may not have been asked of you before. It's sort of an abstruse little point here, but you quickly thought then in your head, or you'd rehearsed it, either one, well, wait a minute, most of these people don't have, for misdemeanor offenses, they don't even have lawyers. There's no way they could anticipate the intricacies and forfeiture of 1983. You were very good at either thinking up very quick answers or, again, that trait of rehearsed spontaneity where you'd already been asked the question, you made it seem so fresh. So it was delightful. Now, in finish, we aren't grading your briefs, but I take it you two may be finalists in that score too. So I read the briefs and I thought they were both wonderful. I will say to you, without disclosing conference discussions, that one or more of us was very particular in scoring, and you were separated by 1 point out of 100. That's how close you were. But in the end, and I know you'll congratulate each other, Ms. Medansky, we thought you slightly edged it out. So we will declare you the winner of this moot court.
I won.
The 1 point winner. But
I will
just
unmute
wanna
myself to say thank you, and thank you.
Well, let me say to you both again, I haven't seen a case where the two of you argue, two finalists argue both issues and write briefs as pristine as this. And this is from the bottom of my heart. The most important thing you can take away from this is the friendship you two have for each other, because you've been classmates and you're both spectacularly gifted intellectually. And the biggest positive of this will be if you two stay together and close professionally, helping each other for the rest of your lives. But it's also sort of nice to have done as well as you did in front of your dean, right? So Dean Chemerinsky, I think that's it for us. Do you want to make some final comments?
They were both terrific. I had the chance to tell them while you were deliberating that I thought they both did a superb job. I agree with all of the praise that each of you expressed. And the only thing I'll disagree with is with Chief Justice Higginson. You really did us the enormous favor. Thank you for your preparation. Thank you for participating. And what I hope is that once we can be together again, you'll come to Berkeley and judge a moot court finals for us.
I accept.
Of course.
Wonderful.
Of course.
It was I hope I made